So today we're going to conclude the Matthew Charles Prison Reform Act. So far in Title I, we've covered police reforms, prosecutorial reforms, and today we're going to really dig into the prison reforms. You know, the goal of this legislative package is to end mass incarceration. It's a moral stain on our nation. And this applies directly, this is a federal legislative package, so it applies directly to the 122 prisons that are under the direction of the Federal Bureau of Prisons. They have more than 134,000 prisoners in their custody, more than any individual state. And by making these reforms at the top, we can lead by example on the federal level for the states. Now, a number of these demands come from the 2018 prison strike, where incarcerated people in 16 states, I believe, came up with a specific set of 10 demands, organized hunger strikes, work stoppages, things like that to draw attention to their conditions, their living conditions in prison. And so we can try and address some of those demands in the Blueprint for a Better America. And the first section that we're going to look at today is Section 163, repealing the Prison Litigation Reform Act. What the Prison Litigation Reform Act does is it sets up a two-tiered system of justice to make it harder for incarcerated Americans to have access to the judicial system. According to Prison Legal News, this was proposed as part of the 1994 Contract with America. Back in the 90s, we had about 1 million people locked up in prisons and jails, and as that prison population ramped up, thanks to the things like the crime bill and just this whole getting tough on crime thing, people started suing about crowding, saying their constitutional rights were being violated by these conditions. And so how do we stop people from demanding better rights? You can take away or restrict their access to the courts. And so that's what the Prison Litigation Reform Act did. It got passed by being tucked into a omnibus appropriations bill for 1996, and became law that way. Now, before it had gone into effect, courts were dealing with prisoners' petitions, and in a number of cases, something like 40 states and hundreds of local prisons and jails had ordered into consent decrees and made other agreements to improve conditions. But under the Prison Litigation Reform Act, it required that any court injunctions had to have a finding that the relief, which would address the incarcerated people's issues, there had to be a finding that the relief was the narrowest possible solution. And so nobody had really been putting those into these court orders because it hadn't been required. And so when the Prison Litigation Reform Act went into place, a lot of the existing court injunctions just went away because they no longer met this new standard Congress had enacted. And again, according to Prison Legal News, quote, "Not surprisingly, prison and jail conditions did not improve with the termination of judicial relief." The Prison Litigation Reform Act does some other things. It makes it harder for incarcerated people to access the judicial system by requiring that they exhaust all administrative grievance procedures, all the appeals, everything. It requires them to do everything that they can before filing. Otherwise, their court filing will more than likely be thrown out. And so you can see that there's a conflict of interest, right? If you're alleging mistreatment in a prison, to say, well, ask the prison and say, hey, please stop mistreating me, and ask the people, essentially asking the watchers to be the watchmen, which isn't to say that it can't be effective, but that there can be a conflict of interest. And so Congress said, too bad. You've got to go through all the administrative appeals and everything first before you're allowed to access the judicial system. Put other restrictions in place, restricting incarcerated from filing a lawsuit for mental or emotional injury unless they could also show a physical injury. So they couldn't couldn't collect damages for mental or emotional injuries, such as the ones inflicted by solitary confinement that we'll talk about a little bit later in the hearing. And so Prison Legal News concluded that as soon as the prison litigation reform was enacted, prisoner advocates, they challenged most of these provisions as unconstitutional, but they lost across the board. And so Prison Litigation Reform Act will stay as it is unless Congress changes it. And that's why we're here today. That's the point of the Blueprint for a Better America, to change it for the better by repealing it. So this is a very short section. It's just a straight repeal of chapter 197, chapter 1997E of Title 42. And next chair, I think that concludes my testimony for section 163. And I'd be happy to answer any questions.